Welcome to our comprehensive guide on the Code of Conduct and Investor Protection Measures in the Securities Market. In this video, we'll break down the essential rules brokers must follow, how investors can resolve grievances, and the mechanisms in place to keep your investments safe. Whether you're a new investor or looking to deepen your understanding, this chapter will walk you through the key regulations, dispute resolution processes, and risk disclosures that shape a fair and transparent market. Let's begin by understanding why these measures are crucial for both investors and market participants. Before diving into the details, let's outline what you'll learn in this chapter. We'll cover the Code of Conduct for brokers, the investor grievance mechanism, arbitration processes, risk disclosure requirements, and the importance of Know Your Customer (KYC) procedures. By the end, you'll have a clear understanding of how these frameworks protect your interests and ensure ethical practices in the securities market. Securities and Exchange Board of India (SEBI) has established a detailed code of conduct for stockbrokers under its 1992 regulations. This code sets the foundation for integrity, fairness, and professionalism in all broker activities. It ensures that brokers act with due skill and care, avoid manipulative practices, and comply with all statutory requirements. Upholding these standards is essential for maintaining trust and stability in the securities market. Brokers are required to maintain high standards of integrity, promptitude, and fairness in all business dealings. This means acting honestly, avoiding conflicts of interest, and ensuring that every transaction is conducted transparently. By adhering to these principles, brokers help foster a market environment where investors can participate with confidence, knowing that their interests are protected. Brokers' duty goes beyond just executing trades. They must exercise due skill, care, and diligence in every aspect of their business. This includes staying updated on market developments, understanding client needs, and ensuring that all actions are in the best interest of their clients. Such diligence helps prevent errors, mismanagement, and potential losses for investors. Manipulative, fraudulent, or deceptive transactions are strictly prohibited. Brokers must not engage in activities that distort market equilibrium or spread rumors for personal gain. This rule is vital to ensure that all market participants operate on a level playing field and that prices reflect genuine supply and demand. Brokers are forbidden from creating false markets either alone or in collusion with others. They must not interfere with the fair and smooth functioning of the market. By preventing malpractices, the Code of Conduct safeguards the interests of all investors and upholds the integrity of the securities market. Every broker must comply with all applicable laws, rules, and regulations issued by the government, SEBI, and stock exchanges. This ensures that brokers operate within a legal framework designed to protect investors and maintain orderly markets. Regular compliance checks and updates are part of a broker's responsibilities. Brokers have a fiduciary duty to their clients and the investing public. They must execute orders at the best available market price, inform clients promptly about order status, and ensure timely payments and deliveries. Small investors must be treated fairly regardless of the volume of their business. These duties help build trust and encourage broader participation in the market. Maintaining client confidentiality is a cornerstone of ethical brokerage. Brokers must not disclose or misuse personal investment details or confidential information. At the same time, they should be transparent about their role, whether acting as principal or agent, and disclose any potential conflicts of interest to clients. Brokers should never encourage trades solely to generate commissions or provide false or misleading advice. Recommendations must be suitable for the client's financial situation and investment objectives. This ensures that clients make informed decisions based on accurate and relevant information. When brokers or their employees provide investment advice in public media, they must disclose any personal or employer interests in the securities discussed. This transparency helps prevent conflicts of interest and ensures that advice is unbiased and trustworthy. Brokers must employ adequately trained staff and maintain systems to provide fair, prompt, and competent services to clients. Continuous training and development are essential to keep up with evolving market practices and regulatory requirements. Brokers are also expected to cooperate with each other, especially in comparing unmatched transactions and replacing bad delivery documents. They must protect clients' rights to dividends and other entitlements and fulfill all settlement obligations with fellow brokers. Public advertising of brokerage services is generally not allowed unless permitted by the exchange. Brokers must not use unfair means to attract clients from competitors or submit false statements in required returns to SEBI or the exchange. These rules foster healthy competition and market integrity. Investors are the backbone of the securities market, and protecting their interests is a top priority. If an investor has a grievance against a broker or company, the first step is to approach the concerned intermediary. If unresolved, the investor can escalate the issue to the stock exchange or SEBI, which will independently address the complaint and advise the trading member to resolve it. SEBI has introduced a robust online dispute resolution (ODR) portal to streamline complaint resolution. Investors can first approach the stock exchange, then SEBI's SCORES system, and if still unsatisfied, opt for arbitration. The ODR portal enables online conciliation and arbitration, making the process faster and more accessible for all market participants. ODR portal can be used by investors, clients, listed companies, and various intermediaries such as fund managers, depository participants, investment advisors, mutual funds, portfolio managers, and stockbrokers. This inclusive approach ensures that disputes across the securities market can be resolved efficiently and transparently. Market infrastructure institutions, MIIs, must impanel one or more ODR institutions as service providers. These institutions must meet SEBI's guidelines, including providing details about their registration, governance, and panel of conciliators and arbitrators. This ensures that only qualified and independent entities handle dispute resolution. MIIs, in collaboration with their impaneled ODR institutions, are responsible for developing and operating the ODR platform. SEBI oversees the process to ensure proper functioning. The platform connects with SEBI's Securities portal and provides access to all market participants for time-bound dispute resolution. If an investor's grievance is not resolved by the market participant or through escalation to MIIs or SEBI, the investor can initiate the dispute resolution process via the ODR portal. Both investors and market participants can use the portal to file complaints, upload supporting documents, and track the status of their cases. The ODR portal uses a round-robin system to allocate disputes among impaneled ODR institutions. After a review by the relevant MII, the complaint is referred for amicable resolution. This allocation ensures fairness and prevents overburdening any single institution. Conciliation is the first step in dispute resolution. An independent conciliator is appointed to help parties reach a mutually agreeable solution within 21 days, extendable by 10 days with consent. If successful, the agreement is executed online. If not, the conciliator determines the admissible claim value and parties may proceed to arbitration. If conciliation fails, the conciliator notifies the parties and the ODR institution of the admissible claim value. The investor can then pursue online arbitration. If the market participant wishes to arbitrate, they must deposit the full claim amount with the MII before proceeding. This ensures that funds are available for potential payouts. Fees for conciliation and arbitration are stipulated by SEBI and typically borne by the MIIs, who recover them from the market participant against whom the complaint is raised. Market participants cannot pass these costs on to investors. Late fees apply if the process is initiated after certain deadlines. Arbitration is a quasi-judicial process under the Arbitration and Conciliation Act, 1996. If conciliation fails, a sole arbitrator or a tribunal of 3 arbitrators for larger claims is appointed within 5 days. The arbitrator must be independent and qualified, ensuring impartial resolution of disputes. For claims above RS1 lock, hearings are held and awards are passed within 30 days, extendable by another 30 days if needed. For smaller claims, a document-only process is used. The arbitrator can also provide interim relief if required. These strict timelines ensure speedy resolution for investors. Once an arbitral award is issued, the market participant must comply within 15 days or as specified. MIIs assist investors in enforcing awards. If the losing party wishes to challenge the award, they must declare their intention within 7 days and deposit the full award amount before proceeding. Conciliation and arbitration are conducted entirely online, allowing participation via audio-video technology. Investors can also use investor service centers for access. The venue is deemed to be the investor's permanent address or principal place of business, making the process convenient and accessible. Arbitration fees are based on the claim amount with specific slabs outlined by SEBI. For example, claims up to RS1 lock incur a lower fee, while higher claims have proportionally higher fees. Late initiation of arbitration results in doubled or additional fees, ensuring timely resolution. All agreements between market participants and investors now include provisions for online conciliation and arbitration via the ODR portal. Market participants must promptly address complaints, inform clients about the ODR and Securities portals, and ensure staff are trained to handle disputes and participate in online processes. If a trading or clearing member defaults, the stock exchange takes specific steps to protect investors. Investors are notified to lodge claims, and information about defaulters is published on the exchange website. Transparency in the grievance redressal process is maintained through regular disclosure of complaint data. Investor Protection Fund (IPF) is established by stock exchanges to compensate clients of defaulting or expelled trading members. The fund is administered through a trust and receives contributions from listing fees, penalties, and other sources. It ensures that legitimate investment claims are settled even if a broker defaults. Stock exchanges contribute to the IPF through listing fees, penalties, and income from investments. At least 70% of interest earned is reinvested, while up to 25% can be used for investor education. The fund is reviewed biannually to ensure adequacy, and compensation limits are set in consultation with SEBI. Claims against defaulting trading members are reviewed and, if legitimate, compensated from the IPF. The stock exchange discloses the IPF corpus and claim processing policies on its website. Claims arising from speculative transactions are not eligible for compensation, and late claims may be treated as civil disputes. SEBI has standardized the use of power of attorney (POA) in favor of brokers and depository participants. POA is optional and should only be used for specific purposes like settlement obligations and pledging securities. Misuse of POA is strictly prohibited, and clients can opt for alternative authorization methods. To enhance transparency, SEBI introduced the DMAT debit and pledge instruction (DDPI) as an alternative to POA for transferring securities towards settlement obligations and pledging. Clients can choose DDPI or use physical or electronic delivery slips, reducing the risk of misuse. Opening a new trading account requires completing a KYC process. Clients must submit a KYC form, proof of identity and address, and other documents. The process ensures that brokers know their clients and helps prevent illegal activities like money laundering. PAN is mandatory for all market participants. SEBI allows brokers to use technology for online KYC, including e-sign, video verification, and digital document submission. This makes account opening faster and more accessible, especially for remote clients or those with disabilities. Brokers must ensure the security and authenticity of all data collected. Clients are categorized as low, medium, or high risk based on factors like transaction volume, business activity, and payment patterns. High-risk clients undergo enhanced due diligence to prevent unlawful transactions. This risk-based approach helps brokers monitor suspicious activity and comply with anti-money laundering regulations. Central KYC Registry (CKYC) is a government initiative to centralize KYC records for all financial sector participants. Once registered, investors don't need to repeat KYC for different entities. CKYC is managed by CERSAI and now covers both individuals and legal entities, streamlining compliance across the industry. SEBI has mandated that digital KYC processes be accessible to persons with disabilities. This includes allowing guardians to sign, using alternative verification methods, and ensuring that technology barriers do not prevent account opening. These measures promote financial inclusion for all investors. Each client is assigned a unique client code (UCC) linked to their PAN. Brokers must register the UCC with the stock exchange before executing trades. This system enhances traceability, prevents fraud, and ensures regulatory compliance across all transactions. Clients must be made aware of the risks involved in trading, especially in derivatives. The risk disclosure document outlines market risks, liquidity risks, leverage risks, and other potential pitfalls. By signing this document, clients acknowledge their understanding and acceptance of these risks. Brokers must monitor client transactions for suspicious activity related to money laundering or tax evasion. Any such transactions must be reported to the Financial Intelligence Unit (FIU) within 7 days. Brokers are prohibited from informing clients about these reports, ensuring the integrity of the surveillance process. In summary, the securities market is governed by a robust framework designed to protect investors and ensure ethical conduct by brokers. From the code of conduct and grievance redressal mechanisms to KYC and risk disclosures, every measure aims to foster trust and transparency. By understanding these protections, investors can participate confidently and securely in the market.